Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, May 22nd, 2024. And I'm very excited about today's show because we have a special guest and we also have a cert petition. So it's kind of a twofer on today's Short Circuit. So we're going to talk to our special guest in a moment, who is a seasoned appellate practitioner. Then we're going to go to one of my colleagues who has a case from the Second Circuit about IJ's old bête noire, eminent domain abuse. And this is a different twist than some of you are used to about eminent domain. Some of you, of course, remember the Kelo case from 19 years ago now about private takings and all that and the Fifth Amendment. Well, this is a new spin on that issue that hopefully is making its way to the U.S. Supreme Court. So we'll get to that first, and then we will get to a case from the Supreme Court of Texas. So mixing it up a little bit with a state Supreme Court case this week. But first, we're going to talk to a Texan litigator. So Jason LaFond is senior counsel at Yetter Coleman in the great state of Texas. He resides in the Austin area. He's a graduate of the University of Michigan Law School. He clerked for Judge Allison Duncan of the Fourth Circuit and for Thomas Grisey of the Southern District of New York, and has argued all kinds of cases all over the place, especially in the Fifth Circuit, which we know very well here on Short Circuit. So, Jason, welcome.
Thank you for having me. It's great to be here.
So, Jason, I warned you this was coming. You've argued many more cases than I ever will, and I'm sure many of my colleagues have. What is something about appellate practice in the federal circuit courts, name your circuit, could be the Fifth Circuit, could be somewhere else, that even those of us who do appellate work maybe don't know about and is just kind of quirky or interesting?
Well, I'm gonna give you two. One is sort of just nice, and the other one I think has a real effect on how cases go. The first one is that my what I'll call my real home circuit, the Fourth Circuit, where I clerked, they have they think of themselves, and I think it generally is the most collegial court in the country, and one of the things that keeps it so collegial is that the panel after every sitting, they go out to lunch together, and the clerks go out to lunch together. But what I like the best now as a practitioner is that after each argument, the panel gets down from their seats, comes down and shakes the hand of counsel.
That's nice.
Before going back up, which is
I've
really
been to
nice.
A couple courts that do that after the argument, and it's always feels good.
Jason, do they fist bump now in this post-COVID era?
Well, so my judge, who was always very entertaining in very sort of Southern ways, well before COVID, whenever she would come down and shake the hands of the lawyers and then immediately go for the hand sanitizer. She, going down to the hoi polloi, back up, got to make sure to clean up afterwards. Always thought it was funny, but no, during COVID, I'm sure most of it was remote anyway. But yeah, no, I was just there arguing a couple weeks ago, and nice they came down, shook hands. It was nice to see. Now, the thing that actually I think matters, case to case, which maybe lawyers don't know, is the practice of how bench memos are done. So in the Fourth Circuit, every judge on a panel, the clerk would write a bench memo. So you'd have 3 bench memos.
So that's basically a preview, a summary of the case.
Sure. So right. So a clerk will sit down with the briefs and do the research and say, this is a summary. These are the issues that the judge can then use when he or she is looking at the briefs and sort of thinking of questions and asking the lawyers questions. And so, but on the Fifth Circuit, for example, they do shared bench memos. And so you have one clerk that's doing one bench memo for 3 panels. And of course, because I'm biased as a Fourth Circuit clerk, I think that it's a crazy thing to do, to have just one clerk writing a bench memo for the whole panel. And my hypothesis is that you're much more likely to see intra-circuit splits on courts that do a single bench memo than you are for courts where you have more people looking at these things, because things get missed. And then they end up in cases, and then people are like, oh, where did that come from?
Right. So by having 3 bench memos, basically you're distilling all the relevant precedents that you need to know about.
Well, yeah. And you just have more eyes on it. I mean, you think that, clerks are mostly just out of law school. Like, they are smart and they are hard workers, but they have not seen the whole world before they come to clerk. There's just more opportunity for things to get missed.
So, of course, the U.S. Supreme Court famously has a pool for bench memos for cert petitions, which we'll talk about in a moment. That practice. Do you have the same advice for SCOTUS in that way?
I think that there are, and I don't know what it is right now, but there are some number of justices who opt out of the cert pool.
I can't remember what it is now. 1 or 2. I mean, for a long time it was just Justice Stevens, but I can't remember.
And so potentially you have eyes there. I do recognize that there are trade-offs here. I mean, there are only so many work hours to go around, and there are a lot of cert petitions, but I am sure that things also get missed. I mean, you have to know that just by the fact that cases get digged, which is and so the fact that there are cases that have gone to the court that the court then says, oops, no, I think that things are getting missed. And certainly I would imagine that there are much more errors going the other way, because a clerk does not want to be the one whose case gets digged later on, right? And so if you think about the incentives there.
Well, I can think of a case that should be granted and definitely should not be digged, dismissed as improbably granted, and that is Brinkman Hardware. So, which is actually Brinkman versus Town of Southold. So, Jeff, this is your case. What is next in eminent domain and heading to the Supreme Court?
Thanks, Anthony. Before I jump in, I've got a fun appellate fact that I want to
nice.
That Jason's point reminded me of. The DC Circuit has a neat device for dealing with intra-circuit splits. Not the kind of things where you've got panels that are like fighting with each other over what the law should be, but the kind of things that get missed where, you have a precedent and just no one cited it, and you end up deciding some case a different way, and you realize this needs to be resolved. They have a way of doing en banc footnotes. They call them irons footnotes.
That's right, irons.
And they don't use them that often. But basically, if you come across one of these issues, you can just circulate a memo to the rest of the court and say, "Hey, we need to straighten out our precedent here. We obviously don't want to go en banc and have a whole bunch of briefing and get everyone together in this courtroom over this one issue. It was a mistake. It's something that's straightforward." And then they can vote on it. And then when the panel releases its opinion, it has a single footnote, and that footnote is effectively an en banc holding that can overrule prior precedent.
Well, I was going to say, we talked a little bit about that. It was about a year ago, maybe. And I think it was another circuit. It might have been the Fifth Circuit was like basically doing the same thing, but they cited to the DC Circuit because it was so unusual elsewhere.
So I think that the Seventh Circuit does this. The Fifth Circuit, I think, is much more likely to simply rely on its rule of orderliness. So if you're able to spot like an earlier opinion, that earlier opinion controls. Now the Fourth Circuit, if we're going to nerd out here on this stuff, the Fourth Circuit has a way to sort of try to avoid that in the first place, and that is, at least when I was clerking, that any published opinion goes out to the whole court before it gets published. And then any judge can also say, and then a clerk, at least when I was there, a clerk was assigned to look at it as well. It would say, wait a second, like I spot something. Or what was even more likely to happen is, oh, we have a case, like you mentioned something in passing in your opinion. Well, we have a case right now where that issue is sort of front and center. So maybe sort of take that out of your opinion, or sort of leave it more open so that we have room to sort of work with it here. But yeah, the that sort of behind the scenes on bonk practice is really interesting and questionable, but nonetheless interesting.
It sure is.
Now that digression is over, I will talk about my cert petition. So this case is out of the Second Circuit. It's Brinkman v. Town of Southold. And our clients are the Brinkmans. They're a family that owns a small chain of hardware stores out on Long Island. It's a second-generation business. And they, for a number of years, have been looking to open a store in the town of Southold. But they had located a plot of land that they thought was perfect. It was commercially zoned on a busy corner, kind of in the middle of town, but it was undeveloped. It just, had some woods on it. And it took them a while to get together the money to buy it. But eventually they did. And that's when things got weird. It turns out that there was a lot of opposition to this hardware store opening up in town. And, people raised concerns about possible traffic, about aesthetics, about competition for the existing hardware store owner. So there was quite a long process here. They had to hire a local architect and go through a few rounds of revisions. They had town meetings. They paid for a traffic study and agreed that they would pay for any intersection improvements. It turns out the traffic study said there would be no issues at all. They had to pay $30,000 for a municipal impact study to determine what the effect would be on the local economy. And, this process went on for years. Eventually, the town imposed a building moratorium, they called it, centered right on our client's property. But it was selectively enforced, I guess we could say. Everyone else who was in the moratorium zone was able to get exemptions, except for our clients. They challenged the moratorium in state court. The state court said this was probably unlawful. And I think the town saw the writing on the wall. There wasn't going to be any way to stop them. They were complying with all the zoning regulations. The moratorium wasn't valid. So they were going to go ahead and break ground pretty soon, it looked like. So then the town decided that they were going to use eminent domain to acquire our client's property for what they called a passive use park, which is essentially a park with no improvements on it. Now, everyone understood that the point of taking this land for a supposed park was just to stop the Brinkmans. The town had a list of 1,000 properties that it had targeted for potential acquisition for public projects over the long term. Our client's property was not on it. During the years of back and forth with the city over whether they would be able to build this, no one ever said, hey, we're thinking about putting a park on this property. This was something that they really came up with as a last-ditch effort to stop them. Now, it turns out that fact patterns like this actually arise every few years around the country, and there's a lot of precedent about what we call these kinds of pretextual takings. Courts from Connecticut, Massachusetts, Pennsylvania, Georgia, Colorado, New Jersey, and even New York, way back in the middle of the 20th century, have all looked at cases like this and said it's not okay to take someone's property in order to stop them from making a lawful use of it. So we thought that we had pretty good odds here. We had overwhelming authority from around the country, and including from the Connecticut Supreme Court. And normally, federal courts of appeals don't like to create splits with state high courts in the same jurisdiction, because that would mean that if you're standing in Connecticut, you don't actually even know what your property rights are. It just depends which court you end up in. Well, we ended up losing, surprisingly, in the trial court, and then we lost 2-1 in the Second Circuit.
And right off the bat, right? On motion to dismiss.
Motion to dismiss. No discovery. And the majority basically agreed. There was no question under our allegations. We had alleged that the true purpose of this taking was just to stop the Brinkmans from building their store. There was no possibility that the town actually had wanted a park here ever. But the majority said that doesn't matter. And the basis of their opinion, they had a sort of a few rationales. One was this language in the infamous Kelo decision, which I think most listeners probably know all about. There's a line where the majority says, well, obviously government can't take property under the mere pretext of a public purpose, when the actual purpose is to bestow a private benefit. And the Second Circuit panel took that to mean that there is such a thing as a pretext claim, where you look at the true purpose of the taking. But the only thing that makes a pretextual taking illegitimate is if the true purpose is benefiting a private party. If it's something else, it's fine. The government can lie about the reason that it's taking your property. The dissent said, that doesn't make any sense. They were talking about private benefits in that case because that's what that case was all about. But you shouldn't take that one language to mean that the doctrine is limited in that way. And that's not really how you read cases, and it doesn't even make sense. Why would you be able to look at the true purpose of a taking only when it's for a private benefit? The majority also was really concerned about the practical difficulties, it said, in looking for the true purpose of legislative action. But again, this dissent from Judge Menashe pointed out that because this has been the law for so long in so many states, if there were practical difficulties, we would know about them. So this isn't the rule that we are advocating here is not a new rule. It's something that has been the law everywhere and has not proven difficult to administer. Certainly we're not talking here about deposing legislators and trying to figure out like what's deep in their heart. We're looking at objective evidence. Like, did you have any prior plans for a park here? Was this property on the list of 1,000 properties that you might possibly acquire in the next decade? And these are easily verifiable facts. There was also a dispute about whether there was really a split of authority here. The majority quibbled that some of these state court cases might have been decided under their state constitutions. The dissent said, well, at least some of these cases are clearly federal rulings. But there's also no indication that these states were interpreting their state constitutions differently from federal requirements. And this is a feature that comes up in eminent domain cases a lot because most eminent domain cases are litigated in state courts. Usually someone wants to take your property. They have to file a condemnation petition in a state court. So you raise your defenses in state court. And this law is all developed there. It doesn't mean, though, that states are trying to do something different. Usually states think that they're applying kind of a general body of eminent domain law that's the same between state and federal courts. So there are certainly cases where states say, we see what the federal precedent is and we don't like it and we're interpreting our state constitution differently. We raise those claims sometimes. But normally the way federal courts look at state cases is if you're citing state cases and federal cases interchangeably, you just assume that you're interpreting your constitution in lockstep with the federal constitution. There was also some concern raised about the possibility of abuse here in terms of racial minorities, people with less political power, outsiders, and that this would make it very easy to get rid of the kind of people you don't want. The majority said, well, that's what the Equal Protection Clause is for. I think there's a real problem with that, though, because equal protection claims are really difficult to prove. You really do have to know what is in someone's heart. They can always say, well, yeah, we took that African American owned business and put a park there, but it's not because they were African American. It's because we didn't like the aesthetics of that particular business or something. So if you don't really know what the motive is in an equal protection case, it's hard to prove. And it's particularly difficult in land use cases because land is always unique. And usually in equal protection cases, you need to have some kind of a comparator. So it's not like, an employment case or something where you have tons of data and can look at how similarly situated people are treated. Nobody's similarly situated to the owner of property because every single property is unique. We're obviously doing a cert petition in this. We think that it has pretty good odds, both because there's this huge split of authority, but also because this created the split. It upset the status quo, I think it's dangerous, not just because you've got political outsiders and minorities who can be victimized by this, but because it gives local government basically like plenary authority over land use. Anyone who's tried to develop anything knows that land use regulation is pervasive. It's not easy to navigate. Local government has huge authority under zoning regulations. But normally, if you run this gauntlet of regulation, you comply with all the zoning requirements and you get your local architect and you go back and forth with the committees. At the end of the day, you get to build what you want to build. And the town's position here and the Second Circuit's majority position is basically that at the end of the day, government has an unreviewable veto over particular landowners and particular land uses. There's no like residual authority where the landowner who does everything right gets to open his business. You could say that at least this isn't that dangerous because government will have to pay for the property. But I don't actually think that's true. I think that if the Second Circuit's rule were to become well established, then the government would never have to exercise domain to exercise this veto. They could just threaten it. They could say, hey, if you buy this property or try to open this, we're going to put a park on it, so don't try it. And 99% of small business owners are not going to want to have that fight, so they will just accept it. And we've actually seen these kinds of threats before. Anthony, back when you were a real lawyer, we litigated
time ago
this case in Charlestown. Yeah, are you like a thought leader now, or like a public intellectual?
Some may call me that, but I just call myself a talk show host.
All right. So we had this case in Charleston, Indiana, where the mayor of this town was trying to redevelop a poor neighborhood, and they weren't allowed to use eminent domain to take these properties and give them to a developer because Indiana had great post-Kelo reforms that limited that. But he wanted everyone to sell to his developer friend, and there were some holdouts, and he threatened them with putting pocket parks on their property. He said, well, a park is a public use, so if you don't sell to my buddy, I can just take your property and put a park on it. Now, we eventually won that case, but these threats are real, and they are actually happening.
Was it was pocket park? I'd forgotten about pocket parks. Was that a backup to the major plan, which was fining people into oblivion until they sold to the developer? But even if that wouldn't work, it was like this pocket park thing.
Yeah, I think that was the backup because I think they knew that they were not going to be able to fine some of these people into oblivion. Like, our clients, the Keiths, their property was absolutely pristine. Right. They could send out an army of code enforcers with magnifying glasses, and they wouldn't find anything wrong with their property. So they would have had to do something like a pocket park to get rid of them. So I think we've got, every cert petition is a bit of a long shot, but we have a great dissent from Judge Menashe. We've got a big split of authority, and we have a decision that's really upsetting the status quo. So I think this checks a lot of boxes, and I think this is a petition to watch.
Jason, you impressed by the Second Circuit's work?
I am. I was impressed by both judges. or by both the majority and the dissent. I think it's really interesting to see this sort of, I'll just say, like, conservative versus libertarian sort of squabble that people who are sort of in the movement are sort of I think familiar with. Happens on a regular basis. I just, Jeff here is the expert on takings law, and this case raises a lot of questions for me. And do you mind if I do a little sort of moot court here, where I ask
raise the questions, Jason.
Ask Jeff some questions.
So, just asking questions,
Yeah. People are saying, I'm just asking questions. If in an inverse condemnation case for zoning, sort of anything like that, in a normal suit like that, is the plaintiff seeking damages, or is the plaintiff seeking equitable relief to stop the zoning change?
Usually, they're seeking damages.
Yeah. So if the town had done stuff to make it impossible to build a hardware store, the owners would sue for damages in an inverse taking claim.
Possibly, but there are also limitations on zoning authority. In particular, things like you can't do spot zoning.
Yeah.
And this is really an end run around limitations on spot zoning.
Is the spot zoning, is that a takings issue, or is it more of like a due process issue?
That is a good question. It's not entirely clear.
Yeah.
It's the law pretty much everywhere,
yeah.
But its provenance has not been fully explored.
Sometimes it's kind of a state statutory issue, mm-hmm. like just state, not really constitutional, but state police powers, that the state has not given localities that level of zoning to just zone every single property.
So
on its own way.
It's just like the way that the thing that sort of first came out to be in this case is that sort of the way normally these dealing with governments and red tape work is this would be a huge win. Like you've gotten your money from the government. Like normally they're trying to just bury you in red tape, but you have forced them to come out and give you the money. And so to me, that was the sort of normal facts are sort of turned on their head here, where it's like, no, we want to, like, we have fought through the red tape. We want to fight through any more red tape you're going to throw at us. Like you can't take our property. And so that to me is a very interesting aspect of this case. The other part where I have sympathy for the majority, and I think that part of maybe what was driving this case is that there was. I'm going to take you all the way back to Fletcher v. Peck, which is a Chief Justice Marshall opinion from the early 1800s, with fun facts. The Georgia legislature was totally bought off and corrupt, and did a land sale at like super cheap prices. And then land was later sold. And then another bill came along after the honest legislators came in to undo the previous land sales. And so the next buyer sued the person who he bought it from, saying, you sold me this land that you bought from a corrupt state. And it was a contract clause claim saying, the state of Georgia can't undo these land contracts. And there, Chief Justice Marshall is saying there's no corruption exception here. You can't expect us to go and look into the hearts of the legislators. Like that's just that's not something that courts do. And this concern about how to handle legislative and the sort of secret intent of a legislature has been going on since then, and it got, I think, especially among conservative judges, I would say there is special skepticism here because many of these legislative intent rules were developed during heady days of courts interfering with legislators, that now there are a number of judges that are skeptical of that. And tell me if I talk for too long, but Jeff talks about the cases showing no practical problems. But the sort of unstated practical problem is that you have one district court judge making a fact finding on the intent of a legislative body that is then examined under clear error. And so if you get the wrong judge, then you have this pressure where one judge can knock down all this legislation simply by finding a fact that the legislature had the wrong intent. And that, I think that pressure over there drives a lot of skepticism of cases of sort of recognizing, I'm not going to say new because I don't want to prejudge the case, but limiting the areas in which you're going to look behind the intent of the legislature, because of that sort of all these things interacting to give a spot where you can really explode the interference of one branch with the other. And while Jeff swears that you don't need depositions of legislators, that's nice of Jeff, but the future litigants are not going to be bound by that, and that's something that happens. You may be able to take from this. You may be able to guess that I spent some time as a lawyer for a state dealing with these issues where you find a favorable judge and you put facts in and the judge just says, yes, discriminatory intent, the law is knocked down. And then you're up in the appellate court arguing about clear error, and you're sort of behind the eight ball there. And I say that not because I don't think that you're right, Jeff, but just to sort of what I think is a lot of things that are going on underneath here, and why there is skepticism and going to be skepticism over cases in which judges are being asked to judge intent.
So I agree with you as a general proposition. I think the issue here is that intent or purpose is pretty easy to show in this kind of context. And first of all, in terms of the clear error thing and deposing legislators, I think that the pleading standard of Iqbal and Twombly do a lot of work here. There's the earlier Second Circuit decision in Goldstein v. Pataki, which rejected on the pleadings a pretext claim of private benefit. Basically, they said, look, you don't get to go on a fishing expedition alleging private benefit just because you think there's someone who's benefiting a lot and the thing seems fishy. You need some real hard evidence before you're going to get past a motion to dismiss. And well, there are issues with that case. I think that as an articulation of how Twombly works, it makes a lot of sense. I think that in these kinds of cases, if you look back to the 1950s, where there have been decisions like this, like almost every 10 years, there's a big decision on these kinds of pretextual takings. The facts are really similar, and the crucial facts are always about timing. It's like land use takes a lot of planning, and the fact that local government had no interest in doing a particular thing at all until well into someone else's planning process to do something else with it is pretty damning. And I think realistically that's going to be the dispositive evidence in a lot of cases. I'm not suggesting that there would be some categorical rule that no legislator can ever be deposed. I just think that this is not a bare allegation gets you past a motion to dismiss, and then you just go digging. I think that we have cases to model how this should work, and I think that it has proven fairly predictable.
And in fact, in this case, I mean, I think the biggest takeaway the majority even says is it's not contested that this is to stop the hardware store. So it's just that it is for a public use is the town's whole argument, right?
Yeah, and
Jason,
yeah, sorry, go ahead, Anthony.
Well, and Jason, I am sympathetic to your past travails as Assistant Solicitor General for the great state of Texas, but it is part of how the Constitution works that there can be bad motives, and sometimes you got to look under the hood. And I get it gets messy, especially I think what you're alluding to, especially in a preliminary injunction context where you don't actually have a full record yet, and you're on appeal, and you have a nationwide injunction. I am more sympathetic.
Well, yeah, and to be clear, my comment was not that legislatures are doing good things, or that these cases shouldn't be there. Simply the sort of describing what I think this case is sort of pregnant with underneath that are going to be concerns that need to be overcome. The Twombly standards and everything like that. If all judges were angels, you wouldn't need that. You wouldn't need to worry about these things. But I think that even though they won't say it, I think that a lot of circuit court judges and even Supreme Court justices are worried about the district court judges that are not angels. But I'm curious: is there a substantive due process claim about being targeted with a taking, sort of specifically because of what you are and who not obviously not suspect categories here, but sort of the opinion talks about the arbitrary and capricious standard that state courts use and things like that. Which gets close to a substantive due process claim. And I'm curious, Jeff, if that's something that this case sort of blends with.
I think that this is a situation where there's enough precedent that has been under public use clauses that there's not really a need to try to locate the right in substantive due process.
Yeah.
I do think it has some elements of this came up in the oral argument, like an anti-circumvention principle, that there are all of these safeguards built into land use regulation, and states are pretty good about limiting what local government can do because they know how oppressive local government can be when it comes to land use. And this is like one neat trick to evade all state limitations on local land use.
I'm also curious about the public purpose part of this. That it's like parks are public purposes. Like, well, if you turned it into a park solely to benefit the other hardware store owner, because it's easier to compete with a park than another hardware store, then
right.
How do you separate out where you look for what is public?
I mean, and that's the thing. Like, I don't think the majority really confronts the fact that, like, they've already conceded that we do this inquiry, at least in some contexts. I certainly think that under the majority's approach, what if you're taking a park because your buddy, the developer, is like building a bunch of townhouses, and he's like, yeah, my townhouses would be worth more if they're across the street from this gorgeous park. I think under the majority's approach, that would be illegitimate.
One last point I will make is that in the dissent, Judge Menashe cites his own article he wrote with Judge Ginsburg of the D.C. Circuit, Rational Basis with Economic Bite, which was published about 10 years ago in the NYU Journal of Law and Liberty, which is a article I have turned to at times. It's a good explanation of why the rational basis test, as it's currently orchestrated, doesn't make a lot of sense and should have some higher standard for economic liberty. So put that out there. Thank you for Judge Benassi of writing that and then citing his own article. So we are now moving to finish up though. So we're recording this on May 22nd, but when is the cert petition when is the due date?
Our cert petition is due on June 10th.
Okay, great. So listeners can, if it is up when you are listening, can go take a look. And we, of course, will be following this ad IJ in the coming months. But now we're moving from the Second Circuit to the great state of Texas, to the Supreme Court, in fact. And this is a story we have talked about on Short Circuit before, but it's been a little while, which is all the chaos of the spring of 2020 and things being canceled, people being stuck inside their homes, and paying tuition for a product that is not what you thought it would be. This case at Southern Methodist University. And the Supreme Court of Texas has a question about the Texas Constitution and how it relates to all that business that happened in spring of 2020. And Jason's going to walk us through this very interesting opinion about a state constitutional law, and then we can see if the court got it right. So, Jason, take it away.
Thank you, Anthony. And there is a circuit court connection here because it was a certified question from the Fifth Circuit. And the question was whether or not a Texas state statute limiting the liability of businesses for things that happened in the immediate aftermath of the COVID pandemic is an unconstitutional retroactive law, a law that relieves them of liability. And the plaintiff in this case is a gentleman, last name of Hogan, who was a graduate student at SMU. He was finishing up his degree in the spring of 2020 when, under government order, SMU shut down and went remote. I think a lot of people think of Texas as sort of very loose with the COVID rules. At the beginning of the pandemic, however, Texas, was in lockstep, I think, with most of the country in closing things down. And so Mr. Hogan ended up completing his degree online, and then he and a putative class, I don't know that it was certified, of students sued SMU for contract violations that, essentially that he did not get what he bargained for and what he paid for. This is one of many cases in the country, specifically college students and graduate students suing over things that happened during the pandemic and their loss of sort of in-person education that they were promised. They say when they went. The one thing to keep in mind with this particular case is that it's limited to the spring of 2020 when there were state government orders mandating these closures. I think
even in Texas,
and so the claims there are going to be, the claims might be very different for a case in which it was a voluntary closing, but the case ultimately turns on whether or not retroactive means retroactive. And the court says no, does not mean retroactive. And this is, I'm sure there's a German word for this, but this is in a category of cases in which courts say sort of words or symbols. Sometimes those symbols mean what's in the dictionary, and sometimes they are symbols for something completely different. To me, the most famous in federal court is the 11th Amendment, which is very, very specific, dealing with citizens of different states suing a state or of a foreign country the court has read it to mean more for what it was responding to, which was Chisholm v. Georgia, and so reads it broadly as establishing or reestablishing generally state sovereign immunity. And so there again is another thing where it's not what it means in the dictionary. It's what it sort of symbolizes. And I could go off on a tiny tangent here why this SMU case was so interesting to me, having read a different case with sort of similar things, was the Penn East, and dealing with takings, the Penn East pipeline case, which was about whether or not a private company who Congress has delegated takings power to can take property from another state. And the Supreme Court said yes. And Justice Gorsuch, I think, had an interesting concurrence where he says, look, we are literally in the 11th Amendment. This is a citizen of a different state suing a state. So whatever you want to say about waiver and all these other things, we are literally in the 11th Amendment and doing the opposite of what the 11th Amendment says. And I think that it's interesting because if you really take what the court has said about like the 11th Amendment is a symbol, well then, sorry, Justice Gorsuch, yeah, it says that, but we've all agreed that we're not looking at what it says. We're looking at sort of, the symbolism behind it. And I think you see that with the contracts clause in the federal constitution as well, and many other things. But here we have it with retroactive laws in Texas. So Texas has had numerous constitutions. Texas, people hear about Six Flags. It was originally the Six Flags of Texas, and as I'm sure everyone knows, because everyone cares about Texas so much, is that Texas used to be its own country.
Some of our best listeners are from Texas.
Well, yes, and
so don't worry.
And Austin is an IJ stronghold. Understand, and there's a sort of really interesting constitutional history in Texas, where you can go through and look at the changes over the various constitutions and things that happened in between them, in which it sort of becomes more like a legislative, like a statutory interpretation exercise almost. And I think you'll see sort of flavors of that in Justice Blacklock's opinion here. So the class sues, and they run up against a Texas law that relieves defendants of liability, and they seek to get around that law by challenging it as an unconstitutional retroactive law. The case makes it up to the Fifth Circuit. The Fifth Circuit asks the Texas Supreme Court to interpret its prohibition on retroactive laws. And in the opinion, the Justice Blacklock, I think for Texans at least, there's a lot of interesting stuff in here about how you interpret a constitution and sort of what goes into the ideology almost of how we're going to look at constitutions, the same way that with the federal constitution you have battling interpretive theories of how a constitution should be interpreted here. And here Justice Blacklock sort of goes back and forth between what did the words mean to the framers of the 1876 Constitution, which is the current Constitution, first, and what did it mean to the people who ratified the Constitution. And so Justice Blacklock, he starts off with a helpful bit of foreshadowing, where he's describing the, quote, historic events of 2020 and how they raised all these questions that a legislature would have had no reason to think of beforehand and make rules about beforehand. So he's setting up the dilemma that faces a legislature in this scenario where this sort of proverbial bomb hits, and now the And now the legislature has to figure out, as Justice Blacklock says, how to, quote, responsibly and constructively pick up the pieces. And the Texas legislature does that with the Pandemic Liability Protection Act, which specifically protects schools from monetary liability for altering their activities in response to the pandemic. And the plaintiff here says, well, that sure looks like a retroactive law. Things that have happened before, you're now taking away my cause of action retroactively to sue SMU for their breach of contract. And Justice Blacklock, writing for the Texas Supreme Court, says you are right. The Texas legislature has done that. They have retroactively taken away your cause of action, but that's okay, because I'm going to jump ahead to the holding, because unless you have a settled expectation of in some interest, this is going to sound very much like due process, then it's fine for a retroactive law to take a speculative interest away. And the Justice Blacklock gets there by looking at what the case law, what the Supreme Court case law was at the time the 1876 Constitution was ratified. And so I talked about how Texas has had lots of constitutions, and so you have this situation where you have case law interpreting old constitutions, which can then be read to inform what the framers of the new Constitution were probably thinking about when they wrote these things. This is very common in statutory interpretation, in the sort of recodification rules, where if a legislature recodifies a law or amends a law after some court has interpreted it in a certain way, the legislature is deemed to endorse and sort of write in that interpretation. What to me is most interesting, I think that Justice Blacklock reached the right conclusion here, but I thought his reasoning was interesting and maybe a little bit confused, because at first he's talking about what the case law was, and I won't bore the listeners with sort of the cases and their names and what they said, but he's looking at the case law, and he's asking what that said to the framers, and what the framers must have been using this word retroactive to mean. But he also recognizes that when we're interpreting a constitution, we're interpreting what it, quote, would have meant to those who ratified it. Well, it wasn't just the framers who ratified the Texas Constitution. It was the people of Texas who ratified the Constitution. And there's not really any inquiry into what the ratifiers would have thought retroactive meant. Now, I think that if you looked back and you sort of use the rules that we have now for thinking about that, I think you can get to a point where you say, yeah, the people who ratified it also knew that retroactive didn't literally mean retroactive. But I haven't done that work. And so I'm sort of surmising here, but I think it's something that you would do if you were actually asking, what did the ratifiers think? And Justice Blacklock takes a shortcut, and he asks, well, what would the framers have thought? And so there's this case, written by the sort of the most famous old time Chief Justice Hemphill, where he talks about sort of how crazy it would be if retroactive literally meant retroactive. And nobody in any constitution has really thought that retroactive literally meant retroactive. And so from there, Justice Blacklock ends up, through looking at other case law, with the rule that it is only a unconstitutional retroactive law if the legislature is taking away a settled expectation that you have. So then he looks at the claim that the plaintiff is bringing against SMU and sort of analyzes it for its merit. He doesn't say whether or not it would win or lose in a sort of neutral background, but he says it's questionable enough whether or not you would have won that you can't have a settled expectation in it, which is right or wrong is a really interesting way to think about it. I think there's one school that would say, no, you have to actually look at the counterfactual and decide whether or not a case like that would succeed in order to determine whether or not, something has been taken away. Because Justice Blacklock imports the settled expectation rule, that's how he can get to the point where he says, well, if you didn't know for sure that you were going to win, you couldn't possibly have a settled expectation in it.
Sounds a tiny bit like qualified immunity analysis, I have to say, although not nearly as strong as the thumb on the scale as qualified immunity is. But it's kind of like, well, you should have known you were going to lose, so you don't have a claim.
Yeah. I think it's similar in that sort of vein of like things that have to be really clear for you to get anywhere, and that's what you have in this case, which is that unless you can sort of show that you were definitely going to win, then the legislature coming along and dealing with a crazy situation and trying to establish rules for that, the court's not going to find that it violated the Constitution. I have a lot of sympathy for what was going on here, and sort of what the legislature was doing, but again, even if you accept the meaning of retroactive, the idea of settled expectations and looking at the merits of a cause of action is still sort of sui generis to me. And I think it is an outcome. I think there are lots of arguments on both sides as to whether or not it was correct.
What's weird about this to me, and I don't know much about, I don't know anything about the Texas contract clause.
I'm happy to tell you.
I did write a brief with Professor Jim Ely from Vanderbilt about the federal clause, and he literally wrote a book about it. I was mostly, translating his scholarship into brief speak. And what's weird about this case through that lens for me is that normally you would have one of these claims targeting the law that forced the school to close or to go remote. People would usually say like, hey, I had a contract to do X, and then the government does something that makes performance of that contract illegal. And you say, hey, that has upset my expectations here. But that's not what the challenge is to. It's to the thing that removes the remedy. But if the law that made performance of the contract illegal is not itself impermissibly retroactive, then I don't understand how you would have a claim under, it seems like very straightforward that you wouldn't have a contract claim because it's just impossibility. So it seems like they're trying to be a little cute here with the language of this remedy provision because it maps so cleanly onto this constitutional provision. But it all feels a little beside the point to me. Normally, even under older contract clause precedent, where the Supreme Court was much more interested in enforcing that provision of the Constitution, it was not considered an issue to make performance of the contract in the future illegal. It was always about doing things like debt relief, for instance.
And that could be why this is the retroactive clause claim, not strictly speaking a contracts clause claim. And the court even has in a footnote that like we're not dealing with the contracts clause per se here, although they seem pretty much the same thing in this case. But I'm guessing that's because maybe there's this squishiness in the contracts clause jurisprudence, which actually I'm sure is the same. Actually, I wrote about this not long ago that almost every state has exactly the same contracts clause jurisprudence as the U.S. Supreme Court does for the federal contracts clause. There's like no judicial federalism in this area. In fact, I think the only outlier is Texas, and it was this anyway. It had nothing to do with this case. So if they have if they had brought a contracts clause claims, then they think they would have lost for the reasons you're outlining, Jeff. So they kind of do this more quirky retroactive clause, and then the court just looks behind the veil anyway.
Yeah, I think that's right. I think that if the plaintiff here had tried to challenge the COVID restrictions under the contracts clause, it's hard to imagine he would win. And
he'd be suing the state then. And you can't sue the state of Texas for damages unless it's eminent domain and you have a state cause of action like we just figured out at the Supreme Court.
Right.
That's a whole different story.
And to be clear, he's recognizing the impossibility part. The plaintiff focused on sort of, well, I can get around various things with that. Right. And that's sort of where a lot of the work was like, well, that's even more novel and unsettled. And so you really didn't have an expectation there.
You know what I would have liked though? Like I get so impossibility for non-lawyered listeners is where something comes up and it was impossible for you to perform your contract. So you don't owe that service to your counterparty anymore, essentially. And of course, here that's the COVID order. And so what you never see though is the language of the contract.
Yeah.
I kept waiting for what was the actual, whatever the heck contract is a student has, but with his university for a master's program. What are the texts of that contract? And we never even see it, which I guess shows what the court thought of the underlying claim. Whatever the heck that contract says, you have an impossibility.
You get very thorny issues there. Because I also in another life was in-house at the University of Texas at Austin, and as I'm sure that 18-year-olds are not paying that close attention to things, but it's not just like you have like a long contract that you're signing when you go to school. There are hundreds of documents, and it's like, well, what is the contract?
Yeah.
What
policy manuals?
Right. What's included in the contract? It's a whole mess in which I think you'll find a lot of courts trying to find ways to get out of that mess.
One thing the court does not note is that these have been pretty common, as I said earlier, in other courts. Many times in the federal courts of appeals, we've summarized for the Short Circuit newsletter, and some of them have actually gone forward. Most have been unsuccessful, but a few, and it often depends on what the quote contract was with those schools.
What I think would be an interesting case is if you have somebody who is in the position of this plaintiff, and when school goes remote says, well, this is not at all what I bargained for. I'm not going to continue and I'm not going to pay. And then you had a school saying, well, I'm sorry, you have to pay. You have a contract with us. To me, that would be a trickier case. I'm not aware of schools going after people who opt not to continue.
Yeah. And that was one of the facts in this case, was that, he continued along and sort of accepted the modification. Obviously the students are in a very tough spot there. You want to say, no, this isn't what I bargained for. And the court's like, okay, no degree for you then. Like, that's fine.
I think given the time, if the pandemic had started in the US in early January that year, I think there probably would have been maybe situations like that, given that it was middle March for most people. And, there was only a half a quarter to go or half a semester or whatever. It didn't shake out like that. If memory serves, I think maybe some students did that, and the universities let them go. They didn't pursue him for all that money. But in any case, I have just a closing thought before we're done, and that's I'm really glad you brought this up, Jason, about the framers looking at case law when they create the Constitution. And so you do see this sometimes that, okay, so if the courts have figured out that this terminology means X, and then the framers of a Constitution put that terminology in there, then we can assume that they knew that meant that and that. And I have a couple times now, I've gone through some research projects where I read a lot of old like debates in constitutions. Some are preserved, some aren't, but a lot are from this time period, especially. And often these guys have no idea what the courts have said about what they're talking about. And there is some principles of natural justice. And maybe there's one of them who's a lawyer who's actually looked at they didn't have like Westlaw in the room to look this stuff up. And so if that's true for the framers, of course it's true for the general public who then vote on the Constitution. So that's not as useful as you might think, which is frustrating, because especially if it's like a term of art, you kind of have to look at what the courts are saying. But for something like retroactive, it may be they subjectively had no clue about this case law. What do you do with that from an interpretive standpoint? I don't have the exact answer, but it's not necessarily the way to solve it.
No, I think you open a big can of worms though, because I would respond, yeah, and most people who voted on it never read it at all. And so what do you what do you do with that?
Right. I mean, you can go full textualist and the text, and then of course we're back to retroactive.
Yeah. Well,
does it mean what it says?
And let me plug, I think
symbol?
It was Pauline Mayer, her book on the state ratification conventions with the Constitution.
Oh, yeah, that's a great
an amazing book.
Super detailed.
And anyone who's really interested in that stuff, it's an entertaining book, and it's really good. I think it's called Ratification: The People Debate the Constitution.
Yes, we will put a link in the show notes. She also had a great book, of course, on the Declaration of Independence, but that one is worth reading if you're into that stuff. Thank you, Jason. This has been a great conversation, and thank you, Jeff, and good luck. So we will see what the Supreme Court does over the summer and into the fall with our cert petition, and we will watch Jason's cases and how he does in the Federal Court of Appeals and how those bench memos shake out. But in the meantime, I'd ask that everyone else get engaged.